The Trump administration has announced a major shift in America's green card process. And under the new policy guidance issued by U.S. Citizenship and Immigration Services, many foreign nationals currently living on temporary visas may now be required to leave the country and complete their green card process from their home nation. And for decades, applicants on H-1B work visas, F-1 student visas, dependent visas, and even individuals married to U.S. citizens were often allowed to apply for permanent residency through what is known as adjustment of status. But the administration says temporary visas were never intended to become a direct pathway to permanent residency. The new guidance says only applicants facing extraordinary circumstances may be allowed to remain in the U.S. while their green card applications are processed. Officers will decide who qualifies under those exceptions. The move has triggered concern among immigration lawyers and legal immigrants, especially Indian professionals waiting in long employment-based green card backlogs. Experts estimate nearly 6 lakh people already inside the U.S. apply for green cards every year. While more than 1.2 million legal immigrants are currently stuck in long waiting queues, and Indian H-1B professionals are expected to be among the hardest hit because Indians dominate the U.S. tech visa system and face some of the world's longest green card wait times. Immigration attorneys say applicants may now have to return to India for consular processing, even after spending years living and working in America. And there are also concerns for international students on F-1 visas. And since the F-1 category is not considered a dual intent visa, officers could scrutinize whether students originally intended to immigrate permanently when they entered the U.S. Legal experts say the memo does not officially change U.S. immigration law, but it significantly changes how immigration officers could use their discretion while reviewing green card applications. Now, critics argue the policy could create long delays, legal uncertainty, and even family separations if applicants are forced to leave the country. Humanitarian organizations warn that applicants from conflict-hit countries may face even greater problems because some U.S. embassies abroad remain shut or offer limited services. Immigration attorneys also expect the policy to face court challenges, arguing that adjustment of status has been a long-established practice. At the same time, some experts say long-term immigrants with deep family and economic ties to the United States may still have a stronger case under the administration's equities consideration for now. However, the lack of clarity over implementation has left thousands of visa holders, students, and skilled workers waiting for answers about their future in America.